Meetings and directors. Meetings. Meeting means coming together or an assembly of persons in a particular place to discuss lawful business of common interest and based on opinions expressed by participants take decisions in the form of resolutions. Meeting of members is the first type of meeting. Member in relation to a company are three types. One, subscriber to the memorandum with the name entered in the register of members. Second is those who have agreed in writing to become members and therefore their entry in the register of members. Third is as beneficial owners holding shares on behalf of others, name entered in the records of a depository. Members meeting can take the form of annual general meeting which is held each year and the notice will specify it is an AGM. Between two AGMs, the gap will not be more than 15 months. The first annual general meeting can be held within 9 months after the year end, whereas subsequent annual general meetings have to be held within 6 months after the year end. However, in respect of subsequent AGMs, ROC is entitled to give an extension of 3 more months. AGM has to be held during business hours and the day should not be a national holiday. It can be held at the registered office or within the city or village where the registered office is located. If the company fails to call an AGM, a member can approach tribunal which can issue an instruction to convene the meeting, including a direction that even one person present can constitute a meeting. Extraordinary general meeting is another type of meeting of members called by board. It can also be called based on requisition from members who hold 1/10 of the paid up capital or total voting power. The requisition should include the nature of business that the shareholders want to transact thereat. If the board doesn't convene the meeting, the requisitionists themselves can hold the meeting within 3 months from the date of requisition. The cost of holding such meetings can be reimbursed by the company and the same can be deducted from the remuneration payable to the defaulting directors. Extraordinary general meeting can also be ordered by the tribunal where the company finds it impracticable to convene a meeting other than an AGM and the tribunal, suo motu or based on application from any director or member can convene the meeting and also issue an instruction that even one person present can constitute the meeting. The second type of meetings is the meetings of directors. Directors are individuals who direct, control or manage the affairs of a company. The first meeting of the board of directors will be held within 30 days of incorporation and in an year a company is supposed to have 4 board meetings and between 2 board meetings the gap should not be more than 120 days. The third type of meetings is that of class. It might pertain to a class of shareholders for effecting variation in their rights and privileges or for conversion of one class into another, which should be permitted by memorandum or articles and it should not be against the terms of issue. Any resolution passed for variation must be supported by a majority of 3/4. Class meetings can also be meetings of creditors or a class of creditors. The meetings are normally called by the court on application from the company or the liquidator. Whatever resolution passed in the creditors meeting should have support of 3/4 of value of creditors and it should also be sanctioned by the court to be binding on all the creditors. Meeting of debenture holders is another type of meeting where the meeting is held in terms of debenture trust deed or debenture bond and these meetings are held mainly to have variation in the rights of debenture holders during reorganization, reconstruction, amalgamation or winding up. The meeting of contributories and creditors convened by the liquidator, sometimes with the support of court to get their acceptance to the compromise or rearrangement to save the company, and contributory is one who is liable to contribute to the assets of the company when the company is being wound up. In the course of convening any meeting, notice comes first. Notice of a general meeting has to be a clear 21 days notice in writing or through electronic mode. If consented by members holding share capital to the extent of 95% or total voting power to the extent of 95%, a shorter notice may be given to convene a general meeting. The notice shall specify the place, date, day and hour and also the statement of business to be transacted at the meeting. Notice has to be given to the member, to auditor and to the director. Any accidental omission while giving the notice shall not invalidate the entire proceedings. With the notice will be attached an explanatory statement in respect of each item of special business, which comprises a statement of material facts indicating the nature of concern or interest of director, manager, or other key managerial personnel in the business to be transacted. The purpose of an explanatory statement is to enable members to understand the scope and implications of the item of business before they take a decision on the resolution. Explanatory statement pertains to special business. In an AGM, all business is deemed special other than four. 1. Adoption of financial statements and accounts. 2nd, declaration of dividend. 3rd, appointment of directors in place of those retiring. 4th is appointment of auditors. However, in other meetings, all business is deemed to be special. Where any item of business refers to a document, the notice should indicate the time and place where such document can be inspected. When in a meeting, members want to move a specific resolution, they can give a requisition and deposit the resolution with the company 6 weeks before the meeting, and if they want to circulate any statement in this regard, they can deposit that ahead of 2 weeks. Company is bound to circulate the notice to all members along with the statement as relevant. Only condition is the requisitionists are required to deposit sufficient money with the company to give effect to their request. As regards matter to be circulated at the instance of requisitionists, the company or any other person who claims to be aggrieved can approach the central government to get an order to the effect that the circulation need not have to be done, as the provisions are being abused to secure needless publicity for defamatory matter. 2 specific resolutions require special notice. First resolution pertains to appointment of a person as auditor at the annual general meeting, providing expressly that the retiring auditor shall not be reappointed. And the second resolution pertains to removing a director before expiry of his tenure and appointing someone in place of the director so removed. To be eligible to issue resolution of special notice, the member has to have voting powers to the extent of 1% of the total, or the paid up value of shares held by the member has to be not less than rupees 5 lakhs. The resolution with special notice has to be deposited with the company at least 14 days before the meeting, so that the company can give 7 days notice to the members. Where the company finds it impracticable to give a notice of 7 days to members, it can give an advertisement in an English and vernacular daily containing the special notice 7 days before the meeting. After convening comes constituting, and quorum is the first element of constitution. Minimum number of members for transacting business at a meeting is called quorum. Unless articles otherwise provide a large number, in case of a private company, quorum is 2 members personally present. In case of a public company, depending on the number of shareholders, if the number of shareholders is not more than 1000, quorum is 5 members. If the number of members is up to 5000, it is 15 members. And if the number of members exceeds 5000, quorum is 30 members. If the quorum is not present within half an hour from the time appointed for holding the meeting, if the meeting was called by requisitionists, it shall stand cancelled and closed. Otherwise, the meeting shall stand adjourned to the same day, next week, same time and place. If it is some other time and some other place, board has to give a 3 days notice. If at the adjourned meeting, once again, if the quorum is not present within half an hour, the members present shall be the quorum and they can continue the meeting. The second component of conducting a meeting is chairman. Every meeting must have a chairman and is elected in a proper way and is expected to act in an impartial manner for the benefit of the company. Subject to articles, members present can elect the chairman on a show of hands. If a poll is demanded on the election of chairman, it shall be taken immediately. The chairman elected on show of hands continues until some other person is elected chairman as a result of poll, and such other person elected on poll will be the chairman for the rest of the meeting, and a chairman is entitled to a second or casting vote in the case of an equality of votes on an ordinary resolution. The third important component of conducting a meeting is proxy. Proxy is an agent appointed by a member to attend and vote on his behalf. Proxy also means the document by which such an agent is appointed. Between member and the proxy, the relationship is that of principal and agent. A proxy need not be a member of the company, and a proxy can be revoked in 3 ways. 1. By deposit of a new proxy within the stipulated time, or by the member himself attending and voting before the proxy has voted, or by revocation. Something more on proxy. A member entitled to attend and vote is entitled to appoint another person as a proxy. The instrument of proxy shall be in writing and it shall be signed by the appointer or his attorney. It has to be deposited with the company 48 hours before the meeting. A proxy cannot speak in the meeting. He is not entitled to vote except on a poll. A person appointed as a proxy can act as such on behalf of maximum 50 members. Giving 3 days notice in writing, a member may inspect proxies as lodged with the company during business hours, starting 24 hours before commencement of the meeting and ending with the conclusion of the meeting. Two interesting points on voting. When calls are in arrears in respect of shares, articles may provide that no member can exercise any voting right in respect of such shares, and no voting rights can be exercised where the company has exercised any right of lien. Another interesting point is on a poll, a member entitled to more than one vote, either directly or through his proxy, need not have to use all his votes. And whatever votes he casts, he need not have to cast the vote in the same way. Whenever a resolution is put to vote in a general meeting, unless a poll is demanded or there is electronic voting, the default method of decision is voting by show of hands. A declaration by the chairman on passing of the resolution or otherwise by show of hands and an entry to that effect in the minute books shall be a conclusive evidence of the fact of passing of such a resolution or otherwise. In a meeting, poll may be ordered before or after declaration of result using show of hands. A poll may be ordered by the chairman on his own motion, or it can be ordered on a demand made by shareholders who hold by person or by proxy not less than 1/10 of the total voting power, or a paid up capital with an aggregate value of not less than rupees 5 lakhs. A demand for poll shall be taken up immediately in two situations. One, when it is demanded for adjournment of meeting. Two, when it is demanded for appointment of chairman. A poll demanded on any question other than the two shall be taken within 48 hours. The chairman of the meeting shall have the power to regulate the way the poll shall be taken, and the result of poll shall be deemed to be the decision of the meeting. Electronic voting is mandatory in respect of listed companies and a company having shareholders not less than 1000 when it comes to voting facility at general meeting. The notice of meeting will be sent by registered post or by electronic means or through courier. It shall also be posted on the website of the company. 21 days before the general meeting, the company shall issue a public notice by advertisement specifying the business can be transacted by electronic means. It will indicate the date and time the e-voting commences and the date and time the e-voting ends. The facility of remote electronic voting will be open for not less than 3 days, and it shall close at 5 p.m. on the date preceding the date of the general meeting. One who attends the meeting personally, who have not already cast their vote by remote electronic voting, can exercise their right at the meeting through electronic voting system or by ballot. Electronic voting is flexible, but once vote on a resolution is cast by the member, not allowed to change it subsequently. One or more scrutinizers are appointed by the board of directors who shall count votes cast at the meeting, unblock votes cast through remote e-voting. They will make a consolidated report to the chairman 3 days from the conclusion of the meeting, and the results are declared along with the report of the scrutinizer and placed on the website. On receipt of requisite number of votes, resolutions are deemed passed on the date of the general meeting. Postal ballot is another component of conducting the meetings. Central government may require companies to transact certain items of business only by means of postal ballot, but ordinary business where directors and auditors have a right to be heard at any meeting are outside the scope of postal ballot. Facility to vote by electronic means are to be arranged in respect of business under postal ballot. Notices are sent in the normal course by post, email, courier, also placed on the website. Advertisement published in vernacular and English newspaper about dispatch of ballot papers. Postal ballot involves voting by post or electronic means within 30 days from the date of dispatch of the notice. The results are declared along with the scrutinizer's report with the placement on the website of the company. As regards postal ballot, a few of the items of business to be transacted by postal ballot under section 110 subsection 1, alteration of objects clause of memorandum, alteration of articles members to insert or remove provisions under section 2 subsection 68 for constituting a private company, change in place of registered office outside local limits, issue of shares with differential rights, sale of the whole or substantially the whole of an undertaking, or buyback of shares by a company under section 68 subsection 1. Resolutions are an essential part of the conduct of a meeting. A motion, when passed by requisite majority, becomes a company resolution. Resolution is the formal decision of a meeting on any proposal placed before it. It shall be an ordinary resolution if the notice required under this act has been duly given. It is required to be passed by votes cast in favor of the resolution exceeding the votes cast against, including the casting vote. The votes may be cast through vote in person or by proxy or by postal ballot, and it can be on a show of hands or electronically or on a poll. Ordinary resolution is sufficient enough for declaring dividend, appointment of auditors, electing directors, or to pass the annual accounts. As regards special resolution, it is necessary that the intention to propose as a special resolution has been specified in the notice calling the meeting, and regarding the votes cast in favor of the resolution, whether by show of hands, electronically or on a poll, vote in person, proxy or postal ballot, the votes cast in favor shall not be less than 3 times the number of votes cast against the resolution. As regards a resolution passed at an adjourned meeting, it shall be treated as having been passed on the day on which it was actually passed. Regarding documents in electronic form, every listed company or a company having not less than 1000 shareholder family may maintain its records in electronic form. But the requirement is the records may be register, agreement, memorandum or minutes. It must be capable of being readable, retrievable and reproducible in printed form. Once dated and signed digitally, should not be capable of being edited or altered, and it shall be capable of being updated according to provisions of the Act, and the date of updating shall be capable of being recorded on every updating. Under documentation, second aspect, minutes of meeting. Every company shall cause minutes of proceedings to be prepared, signed and kept in such manner as may be prescribed within 30 days of the conclusion of every such meeting. The books kept for the purpose will have their pages consecutively numbered, and they will be very comprehensive, covering every general meeting of any class of shareholders or creditors, every meeting of board of directors or every committee of the board in its meetings, and of every resolution passed by postal ballot, and of all appointments made at such meetings. In respect of minutes of the board of directors meeting or a committee of the board meeting, names of the directors present and names of the dissenting directors in respect of each resolution shall be recorded as a part of the minutes. In respect of minutes in general, chairman shall exercise absolute discretion for inclusion or otherwise of any matter in the minutes on the grounds specified in the Act. As regards minutes as a matter of evidence, it shall be evidence of the proceedings recorded therein. The books containing the minutes kept at the registered office of the company, opened during business hours to the inspection by any member without charge, and available not less than 2 hours each business day. Members shall be entitled to be furnished with a copy of any minutes within 7 working days on payment of relevant fees. As regards filing resolutions and specified agreements, a copy of every resolution or any agreement specified in subsection 3 together with the explanatory statement shall be filed with the registrar in 30 days of passing or making thereof. Every copy of resolution which has the effect of altering the articles and every copy of agreement referred to in subsection 3 shall be embodied in or annexed to every copy of articles issued after passing of the resolution or making of the agreement. As regards matters specified in subsection 3 of section 117, the provisions shall apply to special resolution, resolutions which have been agreed to by all members, any resolution of the board of directors or agreement executed relating to appointment, reappointment, renewal or variation of the terms of appointment of a managing director, resolutions or agreements which have been agreed to by any class of members, resolutions requiring a company to be wound up voluntarily, and resolutions passed in pursuance of section 179 subsection 3 by a board meeting for buyback, borrowing or investing and related matters. Filing reports is a concluding part of documentation. Every listed company to prepare a report on each AGM to file with ROC within 30 days of conclusion of the AGM. It contains day, date, hour, venue, appointment of chairman, number of members attending, quorum, compliance with respect to calling, convening and conducting the meeting, business transacted at the meeting, It is a fair and correct summary of the proceedings, and it shall be prepared in addition to the minutes of the meeting. Directors of a company. Nature and duties of directors. Director appointed to the board of a company. Board of directors, collective body of the directors of a company. Managing director, director by virtue of articles, agreement or a board resolution or a resolution general meeting is entrusted with substantial powers of management of the company and includes a director occupying the position of managing director. Whole-time director includes a director in the whole-time employment of the company. Specific duties under section 166, a director to act in accordance with the articles, for the benefit of its members, act in good faith, protect interests of company, employees, shareholders, community and the environment, exercise duties with care, skill, diligence and exercise independent judgment, not involve in conflict of interests, not achieve any undue gain or advantage and not assign his office. Type and appointment of directors. Every company shall have a board of directors consisting individuals as directors. Minimum number of 3 directors in case of a public company, 2 directors in case of a private company and 1 director in case of a one-person company. Maximum of directors can be 15. A company may appoint more than 15 directors after passing a special resolution. Such class or class of companies as may be prescribed shall have at least 1 woman director. Every company shall have at least 1 director who stays in India for a minimum of 182 days during the financial year. Every listed company shall have at least 1/3 of the total number of directors as independent directors. Any fraction shall be rounded off as 1. Where articles are silent, subscribers to the memorandum deemed to be the first directors of the company. Every director be appointed by the company in general meeting. Every person proposed as director shall furnish his director identification number and a declaration that he is not disqualified and shall also give his consent, and such consent filed within 30 days of his appointment. At every annual general meeting, not less than 2/3 of the total directors are liable to retire by rotation and be appointed by the company in general meeting. The total number of directors shall not include independent directors. The first directors retire at the first annual general meeting. At every subsequent AGM, 1/3 of directors as are liable to retire by rotation shall retire. The directors to retire are those longest in office. Between persons who became directors on the same day based on agreement among themselves or by lot. At an AGM, a director retires. The company fills up the vacancy, appointing the retiring or some other person. If the vacancy is not so filled up and the meeting not expressly resolved not to fill the vacancy, the meeting shall stand adjourned till the same day in the next week. If at the adjourned meeting it is not filled up and the meeting not expressly resolved not to fill the vacancy, the retiring director is deemed reappointed unless resolution for reappointment was lost, or the retiring director expressed his unwillingness to be so reappointed, or he is not qualified or is disqualified for appointment, or a resolution whether special or ordinary is required for his reappointment by virtue of the act. Board has the power to appoint an additional director if empowered by articles, and the additional director shall hold office up to the next annual general meeting. Board can also appoint an alternate director if authorized by articles or by a resolution of general meeting, and such alternate director shall act for a director during his absence for a period not less than 3 months from India, and he shall vacate when the director returns to India. To be appointed as an alternate for an independent director, one needs to be possessing qualifications of an independent director. Company's board is also authorized to appoint a nominee director from any institution or government, and if the office of any director appointed in a general meeting is vacated before his term, such a casual vacancy can be filled by the board of directors, but such appointment shall be subsequently approved by the members in a general meeting, and any person so appointed shall hold office only up to the residual term of the director in whose place he is appointed. Minimum 2 independent directors are required to be held by a public company having a paid up capital of rupees 10 crore or more, or a public company having turnover of 100 crore rupees or more, or a public company which in aggregate has outstanding loans, debentures and deposits exceeding rupees 50 crores. Any intermittent vacancy of an independent director shall be filled up by the board at the immediate next board meeting, or 3 months from the date of such vacancy, whichever is later. The position of independent director is unique in that he is not a managing director, nor a whole-time director, nor a nominee director. He is a person of integrity, possessing relevant experience and expertise in disciplines related to company's business. He is not a promoter, nor related to promoters or directors, has no pecuniary relationship other than remuneration, neither himself or relatives hold position of a key managerial personnel of the company, and none of his relatives is holding any security of or interest in the company, nor is he or they indebted to the company. An independent director is not attracting provisions on retirement by rotation. He is not entitled to any stock option, but may receive remuneration by way of fee, and his office is up to 5 consecutive years, but eligible for reappointment on passing a special resolution. He can hold office for not more than 2 consecutive terms, and any change affecting his status as an independent director is required to give declaration confirming on the criteria of independence. Every listed company is required to have at least one woman director. Every other public company having a paid up share capital of rupees 100 crore or more, or turnover of 300 crore or more, shall appoint at least one woman director. Any intermittent vacancy of a woman director to be filled up by the board at the immediate next board meeting, or 3 months from the date of such vacancy, whichever is later. A listed company can opt for appointment of a small shareholders suo motu, considered as an independent director. It can also have a small shareholder director elected by the small shareholders upon notice of not less than 1000 small shareholders, or 1/10 of the total number of such shareholders, whichever is lower, not liable to retire by rotation, tenure not to exceed 3 years, on the expiry of first term not eligible for reappointment, not to hold the position in more than 2 companies at the same time as a small shareholder director. The second company shall not be in a business competing with the company. Directorships, including alternate directorships, not to exceed 20 at the same time. Maximum number of public companies shall not exceed 10, and members by special resolution are at liberty to specify lower number of companies in which a director of the company may act as a director. Disqualification specified under section 164: unsound mind declared by competent court, undischarged insolvent, or applied to be adjudicated insolvent, application is pending, convicted by a court and sentenced to imprisonment not less than 6 months, order disqualifying passed by a court and the order is in force, and he has not paid any calls and 6 months have lapsed from the last day fixed for payment of call, or convicted of offence related to related party transactions during the preceding 5 years. A director is not eligible to be appointed or reappointed for offence committed by the company where the company has not filed financial statements or annual returns for a continuous period of 3 financial years, or has failed to repay deposits, debentures, or interest thereon, or pay dividend declared, and failure continues for 1 year or more. And in respect of a private company, articles can provide for any additional disqualifications for appointment as a director. Vacation of office results from section 167, where a director incurs disqualifications specified in section 164, absents all meetings during 12 months, or contravenes section 184 relating to entering into contract in which he is interested, or he is disqualified by an order of a court or a tribunal, or he is convicted of an offence and sentenced to imprisonment for not less than 6 months. Vacation of office also results when he is removed in pursuance of the provisions of this act, or having been appointed by virtue of his holding any office or other employment, he ceases to hold such office or other employment in the company. A private company may by its articles provide any additional grounds where all directors vacate their offices under any disqualification. The promoter or the central government shall appoint the required directors to hold office till directors are appointed by the company in the general meeting. A director may resign by giving a written notice to the company, and the board shall take note of it, make the necessary filings with the registrar of companies. The fact of resignation will be incorporated in the report of directors to be presented in the immediately following general meeting. Resignation takes effect from the date received by the company or the date mentioned in the resignation. Director is also eligible to forward a copy of of his resignation to registrar within 30 days. Pursuant to section 169, a director may be removed by ordinary resolution after giving opportunity of being heard. A special notice is required to remove a director or appoint somebody at the meeting he is removed. The provision will not apply in respect of directors appointed by principle of proportionate representation. On receipt of notice to remove the director, the company copies the director and he shall be entitled to be heard at the meeting. Where the director makes a representation and requests notification to members, the company shall do so. If copy is not sent, the director may, besides his right to be heard orally, require his representation to be read out at the meeting. If the company approaches tribunal stating circulation is being used for getting undue publicity and tribunal accepts company's view, representation need not be sent nor it be read out at the meeting. Vacancy created by removal may be filled up by appointing another person provided special notice has been given. Else it can be filled up as a casual vacancy. The new incumbent will hold office till the residual tenure of his predecessor. Section 173 deals with meetings of board. States first meeting of the board to be held within 30 days of incorporation. Thereafterwards 4 meetings to be held every year. Gap between 2 board meetings should not be more than 120 days. Participation of directors in a board meeting may be either in person or through video conferencing or other audio visual means, with recording and storing of proceedings of such meetings done along with date and time. A meeting of the board can be called by giving a clear notice of 7 days in writing, sent by hand delivery or by post or by electronic means. Meeting may be called at a shorter notice provided at least one independent director shall be present at the meeting. In case of absence of independent directors from such meeting of the board, decisions of such meeting shall be circulated to all directors and they shall be final only on ratification thereof by at least one independent director if any. Quorum in respect of a meeting of a board of directors shall be 1/3 of its total strength or 2 directors, whichever is higher. Participation by video conferencing or by audio visual means is included for purposes of quorum, where at any time the number of interested directors exceeds or is equal to 2/3 of the total strength. Directors who are not interested and present at the meeting, being not less than 2, shall be the quorum. Where a meeting of the board could not be held for want of quorum, the meeting shall be adjourned to the same day, same time and place next week, or if that day is a national holiday, till the next succeeding day. Passing of resolution by circulation under section 175. Resolution is circulated in draft to all directors or members of committee at their addresses in India by hand delivery, post, courier or through electronic means. It is approved by a majority of the directors or members who are entitled to vote on the resolution. It is noted at a subsequent meeting of board or committee thereof and made part of the minutes of such committee. Where not less than 1/3 of directors require, the resolution must be decided at a meeting. The chairperson shall take it to be decided at a meeting of the board. A company may pay sitting fee to a director for attending meetings of the board or committees thereof. Such sum as may be decided by the board of directors. It shall not exceed rupees 1 lakh per meeting of the board or committee thereof. Sitting fee will be on par with each other between directors, be it independent director or woman director. The board of a listed company shall constitute an audit committee comprising of a minimum of 3 directors with independent directors forming a majority, looking into remuneration in terms of appointment of auditors, review and independence of audit process, examination of financials, approval of transactions with related parties, scrutiny of intercorporate loans and investments, valuation of undertakings or assets of the company, evaluation of internal controls and risk management systems, and monitoring and use of funds raised through public offers. Audit committee shall have authority to investigate any matter in relation to the items referred to it by the board. An audit committee can make an omnibus approval for related party transactions subject to conditions. Where audit committee does not approve the transaction, it shall make its recommendations to the board. The auditors and the key managerial personnel shall have the right to be heard in meetings of the audit committee. Where board not accepted recommendation of the committee, it shall disclose it in the report along with its reasons. The board report under section 134 shall disclose the composition of an audit committee. Every listed company shall establish a vigil mechanism for directors and employees to report genuine concerns. A nomination and remuneration committee pursuant to section 178 can be formed by the board of directors of every listed company. company consisting of 3 or more non-executive directors, out of which not less than one half shall be independent directors. It shall identify persons who are qualified to become directors and who may be appointed in senior management. The committee shall specify the manner for effective evaluation of performance of board, its committees and individual directors. It may recommend to board a policy on the remuneration for directors, key managerial personnel and other employees. Salient features of the policy along with web address, if any, shall be disclosed in the board's report. The board of directors has wide powers to exercise all such powers and to do all such acts as the company is authorized to do, subject to provisions contained in articles, act, memorandum or regulations made by the company in general meeting. The board shall not exercise any power which is required to be exercised by the company in general meeting. Board has wide powers to exercise in its meetings by means of resolution, to make calls, to authorize buyback, to issue securities, to borrow monies, to invest funds, to grant loans or give guarantees, to approve financial statement and board's report, to diversify business, to approve amalgamation, merger or reconstruction, and to take over or acquire substantial stake in another company. Of its powers, the board by a resolution may delegate to MD, manager or a committee of directors or any other principal officer 3 powers: to borrow monies, to invest the funds of the company, and to grant loans or give guarantees, subject to limits to be specified. There are 4 specific powers which the board can exercise only subject to the consent of the company by a special resolution: to sell, lease or otherwise dispose of the whole or substantially the whole of the undertaking of the company, undertaking wherein investment exceeds 20% of its net worth or it generates 20% of its income; to invest otherwise than in trust securities compensation received from any merger or amalgamation; to borrow money where borrowings exceed aggregate of its paid up share capital, free reserves and securities premium; and to remit or give time for repayment of any debt due from a director. A non-government company in existence for not less than 3 financial years may contribute any amount to any political party. Such contribution can be made directly or indirectly, shall be authorized by a resolution passed at the meeting of board of directors. Every company in its profit and loss account shall disclose the total amount contributed during the financial year. It shall be made by an account payee check, bank draft or by use of electronic clearing system through a bank account. Expenditure on advertisement in any publication where such publication is by or on behalf of a political party or for advantage of a political party shall be deemed to be a contribution for a political purpose. Disclosure under section 184. Every director at the first meeting of the board in which he participates as a director and thereafter at the first meeting of the board in every financial year or whenever there is any change in the disclosures already made, then at the first board meeting held after such change disclose his concern or interest in any company, companies or bodies corporate, firms or other association of individuals where he holds more than 2% shareholding or is a promoter, manager, CEO of that body corporate, or with a firm or other entity where he is a partner, owner or member. Where any director is interested or concerned subsequently, if he becomes concerned or interested after the contract or arrangement is entered into, he shall disclose his concern or interest forthwith when he becomes concerned or interested, or at the first meeting of the board held after he becomes so concerned or interested, he shall disclose at the meeting in which the contract or arrangement is discussed and shall not participate in such meeting. A contract entered into without disclosure or with participation is voidable at the option of the company. No company shall advance any loan or give any guarantee or provide any security for any loan taken by a director of the company or of a company which is its holding company or any partner or relative of any such director or any firm in which such director or relative is a partner, with the exception where a special resolution is passed by the company in general meeting and the loans are utilized by the borrowing entity for its principal business activities. The restrictions under section 85 on loans to directors is not applicable in 3 specific cases. 1. For giving of any loan to a managing or whole-time director as a part of conditions of service as per a scheme approved by the members by a special resolution, or a company which in the ordinary course of its business provides loans or gives guarantees or securities, or any loan made by or guarantee given by a holding company to its wholly owned subsidiary for utilization by the subsidiary company for its principal business activities. No company shall enter into related party transactions except when the board gives its consent. The transactions may relate to sale, purchase or supply of any goods or materials, or selling or buying of property of any kind. It may also be a proposal of leasing property or availing or rendering of any services. The contract might also cover appointment of agent for purchase or sale of goods or property, or related parties appointment to office or place of profit, along with an underwriting contract for subscription to the securities of the company. Where the transaction value is beyond specified limits during a financial year, it is required to get prior approval of company by resolution in a meeting. No restrictions shall apply to company transactions in its ordinary course of business unless it is not on an arm's length basis. No board member shall vote on a resolution if such member is a related party. Passing the resolution not applicable for transactions between a holding company and its wholly owned subsidiary. Every contract shall be referred to in the board's report to the shareholders along with justification. Contracts entered into by a director or employee without approval from board or by a resolution in the general meeting, if not ratified at a meeting within 3 months, shall be voidable at the option of the board or shareholders, and the director's consent shall indemnify the company against any loss incurred therefrom. Guidelines in respect of appointment of managing director, manager or whole-time director. No coexistence of managing director and a manager. Term not to exceed 5 years at a time. Not to employ one who is below 21 years or attained 70 years, beyond 70 permitted by passing a special resolution, who is an undischarged insolvent or has at any time been adjudged so, or has suspended payment to his creditors or made a composition, or at any time convicted and sentenced for more than 6 months. Section 197, ceiling on managerial remuneration. A public company shall not exceed 11% of net profits under section 198. Company in general meeting may authorize exceeding 11% subject to provisions of schedule 5, except with the approval of the company by special resolution. The remuneration shall not exceed 5% of net profits to any one of managing director, whole-time director or manager. If more than one, not to exceed 10% to all such directors and managers taken together. Remuneration to directors not to exceed 1% of net profits if there is an MD or WTD or manager, 3% otherwise. Progress review of company meetings. Every company has to hold a general meeting every year, and it is called annual general meeting, and it should be held on a day when it is not a national holiday. First annual general meeting is given a time concession. It can be held within 9 months from the date of the end of financial year. However, subsequent annual general meetings should be held within 6 months of the closure of financial year, and there is one more requirement. Between two AGMs, the gap should not exceed 15 months. A notice in writing or through electronic mode is required to be given to members in respect of a general meeting, and the notice has to be given 21 days in advance. In respect of an adjourned meeting, the company need to give a notice of not less than 3 days to the members. Every member who receives a notice to attend is entitled to appoint a proxy. The proxy has to be deposited at the registered office of the company at least 48 hours before the conduct of the meeting. A person can act as proxy for a maximum of 50 members. The total value of proxy which is held by one person should not exceed 10% of the share capital or the voting rights. In a private company, quorum required is 2 persons personally present at the meeting of the company. In case of public company, there are 3 slabs. Up to 1000 members, quorum is 5 members physically present. Where the members of the company are from 1001 to 5000, quorum is 15, and if the members are more than 5000, the quorum is 30. At the meeting, the members who are personally present normally select a chairman among themselves by show of hands. However, if the article provides any other method, they will follow that method. In a general meeting, normally all resolutions are passed by a show of hands. However, there can be a method of poll also, voting. A poll demanded on any question, the chairman has to take up within 48 hours of the demand. However, there are 2 demands which are to be attended immediately. First demand is demand for adjournment of the meeting. Second, demand for appointment of chairman. If a chairman has to go through poll and the poll elects a chairman, then the new chairman who is elected by poll will replace the chairman who was selected by show of hand. In the poll, there will be scrutineers who will be collecting the details of the poll and then processing them. They will submit the report to the chairman within 7 days from the day the poll is taken. Section 108 deals with voting through electronic means, that is e-voting. The e-voting, when it opens, it will be open for not less than 3 days and it shall close at 5 p.m. on the date preceding the date of general meeting. And whoever has not voted in e-voting, he can attend the general meeting and cast his vote inside the meeting, either online or physically. Once the vote is cast by e-voting, he is not allowed to vote at the meeting once again, but he can attend the meeting. A copy of every resolution has to be filed with the registrar once it is passed in the meeting. An AGM is completed within the next 30 days. The report of AGM shall be filed with the registrar. As per section 92, a company has to prepare an annual return in the prescribed form MGT7 and the annual return has to be filed with the registrar within 60 days from the date of annual general meeting. The annual return will be signed by one of the directors and the company secretary, and where the company is a listed company, the annual return will also be certified by a practicing company secretary. MGT9 is an extract of annual return prepared by the company and it shall be attached to the report of the board of directors. The annual return, along with copies of all certificates and documents, shall be preserved for a minimum of 8 years from the date of filing with the registrar. The board has got a duty to convene an extraordinary general meeting if 1/10 of the paid up share capital of the company holders submit a requisition. In respect of requisition for EGM, the board has to proceed to call the EGM within 21 days of the receipt. Proceed to means it should take steps to send notice within 21 days. If the board fails to conduct the EGM, the requisitionists can conduct the meeting within 3 months on their own from the date of requisition and all costs will be charged to the company. At the meeting of requisitioning, if the quorum is not there within half an hour, the meeting stands cancelled. There is a method of postal ballot as per the Companies Act where the voting by post takes place within 30 days from the date of dispatch of the voting letter. Postal ballot voting cannot be used for ordinary business because ordinary business has to be conducted in a properly convened physical meeting. Therefore, appointment of auditors, being an ordinary business, cannot be transacted through postal ballot. Any response received in the postal ballot is valid when it is received within 30 days. If it is received after 30 days from the date of issue of notice, it shall be treated as invalid and considered as no reply has been received from the member. Progress review on directors. On minimum directors, the board for a private company will have 2 directors and for a public company, minimum directors is 3. Maximum is 15 for both private and public, but a company can increase the number beyond 15 by passing a special resolution in the meeting of shareholders. Of the directors, only 1/3 can be permanent, in the sense balance has to be retiring and reappointable. Within 30 days of appointment of a director, his consent has to be filed by the company with the ROC. A return containing appointment of directors and other key managerial personnel and changes therein shall be filed with the registrar within 30 days of appointment or change. Director identification number has got the acronym DIN. At every annual general meeting, after the first AGM of the rotational directors, 1/3 or nearest to 1/3 are liable to retire by rotation. Additional directors appointed by the board continue only up to the next annual general meeting. A director may resign by giving written notice to the company. If a director becomes absent from all the meetings held during a period of 12 consecutive months, his seat will become vacant. This is irrespective of whether his absence was with or without leave of absence of the board. A company cannot remove a director if the director was appointed by the tribunal. There should be minimum 4 board meetings in a span of 12 months or 1 year, and between 2 board meetings, the gap should not be more than 120 days. Where a public company has a paid up capital of rupees 10 crore or more, or its turnover is 100 crore or more, or it has got outstanding loans or debentures and deposits of rupees 50 crore or more, exceeding 50 crore to be exact. If any one of these conditions are fulfilled, it is compulsory for a company to have an independent director. An independent director doesn't have any material, financial, pecuniary relationships with the company, its promoters, directors, or its holding company, subsidiaries, or associates. The term of an independent director will be up to 5 consecutive years, and his subsequent reappointment has to be with the support of a special resolution. All reappointments require a special resolution, and normally shareholders approve the appointment of independent directors in their meeting. There is a concept called small shareholder director. He can be appointed for a maximum period of 3 years, and it is only a one-time appointment. There cannot be any reappointment in case of small shareholder directors. Small shareholder means a shareholder who has got value of shares with him not more than rupees 20,000 in face value. To elect a director, small shareholders need the support of 1,000 shareholders or 10% of the total number of small shareholders. A woman director is required to be appointed by a company, minimum one number, where the paid up capital is 100 crores or more or turnover is 300 crores or more on the last date of the latest audited financial statement. Whole-time director is a director in the whole-time employment of the company. A managing director and a whole-time director should meet the minimum age requirement of 21 years. 70 years is the maximum age for a managing director, but shareholders can give approval for the appointment once a person crosses 70 years for his continuation or appointment as a managing director, whole-time director, or manager. ESOP treats a director as an employee. The director may be whole-time director or not, but ESOP doesn't apply to independent director because he is not treated as an employee. A sitting fee of not exceeding rupees 1 lakh could be paid per meeting of the board or per meeting of the committee of the board. The managerial remuneration of a public company can have a remuneration not exceeding 11% of the net profits of the company, and the managerial remuneration is inclusive of remuneration to managing director and whole-time director. In the years of nil profit or inadequate profits, it is not obligatory for a company to pay remuneration to its directors in any financial year. A listed company shall constitute an audit committee comprising of minimum of 3 directors. Nomination committee assists the board in identifying prospective directors from among the members or employees or the team members of the company. A director who was removed from office cannot be reappointed by the board of directors in whatever capacity, be it a casual vacancy or additional director.